Welcome back, everybody, to another shocking courtroom episode of Lockdown 23 and 1. That's right, today in the courtroom, we're not going to witness a defendant get sentenced to life for 20 or 10 years in prison like we typically do. We're actually going to witness a bond hearing, but what takes place during this bond hearing, what the defendant says, is going to paint a perfect picture on how everything in your life could be going great. New kid, new car, white picket fence. And it all goes straight out the window with one bad decision. And I've witnessed people in jail personally going through these same type of situations. They ain't out in them streets committing crimes, but they happen to have committed one, and it was the worst. And chances are later on down the road, you will pay the piper in the penitentiary. So, let's get right into learning from this man's mistakes, ladies and gentlemen. If you're new to the channel and enjoy all things lockup and crime related, then this is absolutely where you need to be. Hit that like, subscribe, notification bell before you leave, and check out my beautifully assorted playlist with many more videos for you to start watching today. Alright, just a little bit of intel on the case and the defendant before we jump into the courtroom. It says, on June 11th, Tyler Beauclair, hopefully I pronounced that right, we'll just call him Tyler for the time being, was driving on US Highway 400 between Leon and Beaumont when his Chevrolet pickup swerved across the center line. It collided head-on with a Toyota pickup truck. 3 people in the Toyota, all from Wichita, were pronounced dead at the scene. Elliot Eichbuer, 46, Arlo Eichbuer, 19, and Silas Eichbuer, 16. Elliot was a middle school teacher in Wichita. Arlo was his son and Silas was his nephew. Tyler had 2 passengers in his pickup and they were injured as well. Tyler checked himself out of the hospital against medical advice and left the state, court documents say. A judge issued a warrant for his arrest and he was taken into custody in Indiana in July. My heart really goes out to all the victims involved in these type of situations. And my condolences go out to the family of the loved ones lost in this one. But now let's jump into the courtroom and witness a defendant tried to talk the judge into letting him hit them streets on bond, bail, whatever you want to call it. It seems to me, though, this guy doesn't really understand the seriousness of his crimes.
At this time, the court will call the case of State of Kansas versus Tyler James Beauclair, case number 2025 CR 303. Darren Deviney, Butler County Attorney, appears for the state. Tyler James Beauclair appears in custody at the Butler County Detention Center Zoom location. Do you have a copy of your charging document before you, Mr. Beauclair?
No, Your Honor.
Then I will inform you in count 1, there is a charge of murder in the 2nd degree, a level 2 person felony. Count 2, murder in the 2nd degree, a level 2 person felony. Count 3, murder in the 2nd degree, a level 2 person felony. Count 4, aggravated battery, a level 5 person felony. Count 5, aggravated battery, a level 5 person felony.
Now, a lot of people might be wondering why he was charged with murder and battery. Keep in mind, he had 2 passengers in his truck as well that were injured. If I were to guess, that's where the battery's coming from.
Since these are serious felonies that are charged in this case, Mr. Beauclair, you will not be asked to plead today. Rather, a preliminary hearing scheduling will be made before your assigned judge. The Honorable Charles M. Hart has been assigned this case. Your next appearance will be before that judge. Judge Hart's next docket would be August 27, 2025 at 2:30 p.m. Your case will be on that docket at that time before Judge Hart. August 27, 2:30 p.m. Mr. Beauclair, do you have the financial resources to hire your own lawyer?
At this time, Your Honor, yes. Just me being apprehended, I haven't been able to proceed with that, but I will be shortly. Yes, Your Honor.
All right, and I don't doubt that, Mr. Beauclair. However, in an abundance of caution, this court's going to go ahead and appoint a lawyer to represent you. These are very serious charges, quite obviously. I want to make sure that you don't go to any future court proceedings without a lawyer representing you. You certainly have the right to hire your own lawyer. And if you feel that's in your best interest, Mr. Beauclair, I encourage you to go ahead and follow through on any plans that you may have to retain your own attorney. Now I'm going to appoint James Watts to represent you. And again, you can replace Mr. Watts at any time with retained counsel. Do you have any questions about that, Mr. Beauclair?
No, Your Honor.
All right. So for now, James Watts will be appointed.
Now that's something I'd never seen in the courtroom before. If I remember correctly, when I was going through my court processes, during preliminary, they would give me a piece of paper and I would tell them about my finances, how much money I got, if any. And I always wrote down 00000. Piss poor, Your Honor. Give me the best the state has to offer. But me personally, I've never seen a judge give a person both. If you say you're going to get a hired attorney and you got the money, job, and finances to back it up, you write it on that paper. They'll give you a court date to come back with your paid attorney. So I did a little research and it says here, in most cases, if you tell the judge you're hiring a private attorney, they will not automatically issue you a court-appointed one. Instead, the judge will typically grant you a short extension or reschedule the hearing to give you time to finalize the hire. However, there are specific scenarios where a judge might still appoint counsel. Financial eligibility, court-appointed attorneys are reserved for those who are indigent, like I just got done speaking about me. No money, no assets, no job, no nothing. Just graduated high school, all you got is your parents. And many people ain't even got that. The second scenario could be preventing delay. If you show up to multiple hearings without an attorney after claiming you would hire one, the judge may appoint a public defender to prevent further delays in the case. Third is a standby counsel. In some complex situations, a judge might appoint a lawyer to be available just in case your private hire falls through, or to ensure the preliminary hearing proceeds without violating your rights. And I believe that's kind of similar to what's going on with this situation. Just a backup to make sure everything runs smooth. 3 people lost their life. It's extreme. You don't want a bunch of continuances and all this, that, and the third, right? So there is a fourth kind of situation. It's called partial indigency. It's if you can afford some but not all of the cost of a private lawyer. A judge might determine that you have partial indigency and appoint a lawyer whom you must later reimburse. It just goes to show you that there are many different kind of routes that you can take with these attorneys.
For now, I'm going to appoint James Watts to represent you. And again, you can replace Mr. Watts at any time with retained counsel. Do you have any questions about that, Mr. Beauclair?
No, Your Honor.
All right. So for now, James Watts will be appointed. Mr. Devaney, I think because it's relevant to the issue of bond in this case, the court wishes to inquire. According to the state's charging document, this incident which led to these charges took place June 11 of 2025, but there's been a number of weeks go by without the defendant being brought before the court or apparently being arrested in the case. Can you explain?
Sure. There were a couple. First of all, we had multiple hospitalizations. We had to gather information. I had filed an inquisition actually and tried to receive as many reports as we could as quickly as possible. Once we received that, we also had information that the defendant had left Kansas and returned back to Louisiana, his resident state. So we tried to keep him under observation there in Louisiana while we were gathering reports and the final information. This was a severe traffic accident, required breakdowns of cell phones and car histories, as well as, like I said, collection of medical evidence with regard to intoxication, some of these other factors that are relevant to the elements of these offenses. So it did take a little bit of time. On top of that, once we had located the defendant, one of the concerns is that he had apparently sold all of his property and taken his family and was later located outside of Indianapolis. And that's where he ultimately was arrested on that warrant. So there has been some time with regard to not just putting the paperwork together, but actually reviewing all the records and making sure that we had the elements satisfied for all of these offenses.
All right. Thank you for that information, Mr. Devaney.
Chances are Tyler was injured, went to the hospital and was treated for his wounds. And as soon as he healed up, he was probably going to go straight to booking, and he knew it. That's probably why he left the hospital early. And it would fall in line and why he was in a different state, sold all of his possessions. He was trying to bob and weave, get the hell out of Dodge. I don't know, right? That's what it sounds like to me. But then there goes me painting a picture in my own mind once again. If it was me in Tyler's shoes, they would have handcuffed me to that damn bed as soon as they put me in the ambulance.
It's a very serious matter. 3 homicide charges, 2 potentially presumptive prison aggravated battery charges as well. The court has some information before it that would suggest that Mr. Beauclair apparently has taken steps which this court would construe as trying to abscond or to avoid capture. Therefore, the court considers him a considerable run risk and a considerable risk not to show up in court for future proceedings. The court will set bond in this
Your
case
Honor.
at $1 million, cash or a professional surety required. You have a statement you wish to make, Mr. Beauclair?
Yes, Your Honor. I would like to make a statement.
Bobby, chill. He ain't even guilty yet.
I
Be
would like to make
careful
a
about
statement.
talking about your case.
Yes, Your Honor. It's only considering the bond. I was hoping to make this statement before bond was considered. Saturday, this past Saturday, I spoke with Detective Bob Albert.
Let me ask y'all a question before we move forward, all right? He said he wanted to make this statement before the bond was made. Do you think what he's about to say here will change the judge's mind and lower that 1 milli bond jank? Without even watching the video yet, if I were to guess, no. Even if he were to lower it, man, it ain't gonna get too much better.
Saturday, this past Saturday, I spoke with Detective Bob Albert. And all these statements of fleeing have been clarified and proven by Detective Bob Albert. Your Honor, I worked away, and I was working away in Kansas, Your Honor. And post to the accident, Your Honor, I was my wife had a due date for our newborn baby, which was 3 days away from the accident. So I did leave Kansas and head back home, and was there for the birth of my child, Your Honor. And we had actually had plans to move to Kansas prior to the accident. We were moving to Kansas, which is the reason my house and property was already sold, Your Honor. The one day after the accident happened on a Wednesday. Friday, we were actually driving back to Louisiana anyway. I was going to travel back to Louisiana anyway to finalize paperwork on the sale of my home in Louisiana, and we were moving to Wichita to move there permanently. So all the selling off property and everything, this happened prior to before I ever even arrived to Kansas. This was already happening, Your Honor. And the second thing I would like to say is it was proven this past Saturday, and I was promised by Detective Bob Albert that would have been reported to the court, but I'm seeing now that maybe it hasn't been reported. But we called Mr. William Wonder on the spot, which is the owner of the company that I was working for, and proved that I was working in Indiana awaiting any charges, to come against me. And then I would just simply turn myself in. We had been in contact with the Butler County Sheriff's Office and told them, if there's any charges to be against me, just give us a call, let us know. I'll just turn myself in, so I don't have to be extradited or anything like that. And we had made an attempt to find that out, and we were told that there was no information on the case that could be told to us. So I do have a wife and kids, and I was just supporting my family, Your Honor. And this has been proven. This is not speculation, Your Honor. This has been proven to Detective.
Man, this defendant, he either been watching a lot of Law and Order or Lockdown 23-1, one or the other. If he is watching me, he knows damn well he's going to Smokeville.
On this past Saturday, and he can attest to that. It was on camera. We called the owner of the company, and he said, yes, sir, Tyler Beauclair was in Indiana working, and then I was apprehended while in Indiana, Your Honor. So I please am asking you to please reconsider, after hearing my statement, reconsider the bond set amount. I'm not a flight risk. I've never missed a trial. I have every intention for due process here in this case, Your Honor, and I'm very financially invested in the case as of already now. So there's no reason for me to flee. But I do have a wife and kids at home that I'm the main breadwinner for, and my wife has a newborn baby right now. He's a month old, and I just want to be able to, support my family during the due process of this case. And I have every intention to be at every trial, and I'll wear a GPS monitor on my ankle or whatever could reassure the court that I would be here. We have reliable transportation for me to be here. So I just ask, Your Honor, I do have a bail bondsman already, working on this. So I would just ask that you please reconsider that, because I promise I'm not a flight risk at all. And the facts that I've offered up to you today would prove that, Your Honor.
I would have been like, Your Honor, you could shackle me to the floor of my bathroom. As long as I'm at my house, I'm good. I ain't leaving. But unfortunately, in reality, he is a flight risk. He sold all his damn property, whether it was before or after, it doesn't matter. Some people look at it like he's got a head start on the situation.
All right. Thank you for your statement, Mr. Beauclair, but it really doesn't change the view of the court here. And I'll tell you why, Mr. Beauclair. What you've reaffirmed for the court is that you do not have established local ties. You have 3 very serious homicide charges pending against you,
Yep.
which any of those charges would be enough to presume that you would be in prison if convicted. So the risk is great for you not to appear. You make promises to the court that you'll do this and you'll do that. But the reality is at this point, the court is going to stay with its original order and establish bond at $1 million, cash or professional surety required. If you feel aggrieved by this court's ruling, you can apply to the assigned judge, the Honorable Charles M. Hart, and seek relief from the assigned judge.
Yes, Your Honor.
At this point, it's $1 million, cash or professional surety required. Furthermore, Mr. Beauclair, as conditions of that bond, I will require GPS monitoring to ensure that you do not leave the state of Kansas for any reason. You're going to be confined to the state of Kansas while out on bond, and all your court appearances, unless Judge Hart orders otherwise, you are to appear at the Butler County Judicial Center in El Dorado, Kansas, for all your court proceedings, whether they're conducted by Zoom or in person. So you have to appear at the Judicial Center in El Dorado for all scheduled court appearances unless relieved from that ruling by your assigned judge. All right, with those orders made and conditions of bond established, Mr. Defendant, is there anything further from your perspective that we need to address here?
Your Honor, other than I did talk to Detective Albert about the interview on Saturday, and most everything that Mr. Beauclair said was relatively accurate as far as the birth of his child, and he was in Indianapolis. He was seeking employment up there, but again, doesn't really change the state's perspective of anything. I don't know that satisfies anything, but I did want to make sure that Mr. Beauclair's promises that were made by the sheriff's department to forward that information, that absolutely was done, and I spoke with Detective Albert a few hours ago.
Very well. Thank you for that statement, Mr. Defendant. All right, Mr. Beauclair, we've got your court date established with Judge Hart, and you have an appointed lawyer. If you desire to seek any relief sooner than that court date, you can work through that lawyer and file whatever motions you deem appropriate with the assistance of your attorney. I believe that's concluded all of our business here this afternoon, Mr. Beauclair.
Your Honor, could I verify one thing before I go? I would like to ask that on the charges, is it known that this was a car accident, Your Honor?
That's not stated in the charging document, no.
It is. This is a DUI. This is a DUI manslaughter charge, Your Honor.
Well, the prosecutor's office have reviewed the facts of the case, and based on their analysis, they believe it's appropriate to file murder in the second-degree charges as a result of what happened. We're not going to get into what happened or what the facts of the case are.
Your Honor, I would just like to make it clear, Your Honor, that this was. It says in the affidavit, Your Honor, that this is unintentional. This was not an intentional act. This was a car accident, Your Honor.
All right. I understand your statement to the court, Mr. Beauclair, but it's not going to change any of this court's orders made here. If there's nothing further, then the Tyler Beauclair matter will currently be in recess. We'll move on to another matter.
Well, there you have it, ladies and gentlemen. We're learning all kinds of prime examples from Tyler today. One, you should never get behind a wheel inebriated because you could take someone's life and be in the same shoes as this guy. And number two, it doesn't matter if you got all your ducats in order. Before you hit that courtroom for that bond hearing or trial, sometimes, man, you're going straight to Smokeville. Especially when 3 people lost their lives. Doesn't matter if it was a DUI situation or not. The severity is extreme, and I don't think the defendant really understood the scope of it. Me personally, I've been expecting no bond situation. So for him to get a milli jank, I mean, he was blessed. But I did tell you I have a little intel, a little conclusion to this story, and it says here, Tyler Beauclair, 25, pled guilty in Butler County District Court to 3 counts of involuntary manslaughter while driving under the influence and 2 counts of aggravated battery. The 3 counts of involuntary manslaughter were reduced from second-degree murder under a plea deal. He's scheduled to be sentenced on April 23rd, and as you know, 23rd is already passed, and I haven't seen no kind of updates on his sentencing, so if I were to guess, it probably got continued. But per usual, I'll keep y'all updated, and if they drop, a courtroom sentencing video, you already know me and y'all will be in the front row seats. As always, though, until the next time, ladies and gentlemen, y'all be easy, be safe, and more importantly than anything, stay free.